Well, hey again, it's Rob Ryder, and it's Thursday, February 16th, 2023. And today, objection: Union is greater than the United States of America. As I've shown in my last couple of videos, there's actually two different versions of the Constitution. And in one of them, it says the president takes the executive power resides in the president of the United States. And the other one says that resides in the President of the United States of America. Ain't that something? Well, I object. The Union overrules the United States of America. The United States of America, if that was a proper term of something, is an entity owned by King George III and his successors, in other words, the British Crown, that was allowed by the Treaty of Peace of 1783 to coexist in the United States, under friendly terms. It's basically a society of the people that really didn't want to leave the king. Not everybody during the Revolution wanted to separate. Obviously, many people were happy with the situation the way it was. Okay, well then, there was a treaty to have both. Now, the problem is this thing called the United States of America has consumed basically the entirety of what would be the Union, through using its British agents, right? An agent of the Crown is called an esquire. Well, there you go. We don't have lawyers anymore. We have esquires. Esquires have taken over as attorneys. We've been overrun by this society called the United States of America. And I don't agree with it because I didn't take an oath to the United States of America. I took an oath to the United States. So that's where my objection starts with. And I am Staff Sergeant Robert Allen Rutluski, U.S. Army veteran, also known as Rob Ryder. Email address is courtofrecord@aol.com, which is always the best way to try to contact me. As a matter of fact, I'm going to be gone for over a week, so please don't call me. Phone's not going to be answered. And you can't leave me a comment on a video to answer because chances are, I know if I try to answer it, it's going to disappear. And a lot of people's questions disappear. So I've been told. I don't know. At YouTube. Can't do anything about it. But you'll find me on YouTube at Rob Ryder, ROBBBRYDER. And if you were at that site, you would see that my last couple of videos were, show me proof that habeas corpus is no longer suspended. And show me the chief judge avenge me of my adversary. Which kind of followed from what I did from the first video, what I did in the second video. This is the third video. What have I done now? And I just want to make a record of it. And that's what we're going to do next. So if you hang on just a second, we'll get started. All right, so let's start here. If you were to go to congress.gov and go to February 7th, 2023, you would find that in the House, at some point in here, there was a reading of the Constitution, right? They actually read the Constitution into the congressional record, and it says it starts on page H715. So we go to page H715, and sure enough, reading of the Constitution. And blah, 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 blee, 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 and finally we're going to get started, and right, they're reading in a Constitution that says that this Constitution for the United States of America. Right there at the end. Let me highlight that. Yeah, I think it will. Right, for the United States of America. And then we keep on reading, and everybody gets their chance at the podium. And now I'm looking for the second amendment or second article. So hang on just a second. Here it is. Article 2, Section 1. The executive power shall be vested in a president of the United States of America. Okay, so Article 2 says the executive power is the United States of America, president, and it says it's the Constitution for the United States of America. Well, that isn't the one the Army uses. Where are you at? All right, this is the Constitution here that's This is Appendix 1 of the Manual for Court Martials, United States, 2019 edition, where says in the preamble, Constitution of the United States of America. And what did we see before? We saw a Constitution for the United States of America. So we wouldn't even need to go any further to say, well, they're not the same. Right? But that was step one. But the important part was who's in charge. In Article 2, this says the executive power shall be vested in a President of the United States. And this one said, right, President of the United States of America. They're two different constitutions. So the one Congress is using, or the people who call themselves Congress, isn't the same one that the military uses. And it's obviously not the same one that I've taken an oath to. Okay, so here's Proclamation 104 from September 15th, 1863. And it says here, by the President of the United States of America. So, but again, the United States of America doesn't have to be the proper name, like of a company. It could be the United States of this thing called the continent of America, which, includes Canada, us, Central America, South America, right? North America, Central America, South America is all one landmass. Until they put the Panama Canal in, there wasn't any break between one part or the other. It's all just America. And we're the United States of that, like Canada is the Canada that's in America, and so forth and so on, right? Because it's talking about the Constitution of the United States. Now, this says, whereas the Constitution of the United States, which one? Constitution of the United States. Now, I want to show you real quick that Congress says that they're using a different one. Because this is the one that you download when you go to the U.S. Code site. United States Codes site for the, which is controlled by Congress. You get a Constitution of the United States of America, 1787. Right? It doesn't say Constitution of the United States. The one that the manual court martial that's used by the armed forces says Constitution of the United States. Right? So, Constitution of the United States, not the same as Constitution of the United States of America. Hope you can see that. Okay, so if we kept on going then in this proclamation, it's all the whereas. This is all the reasons why he's about to do what he's going to do, right? As the President of the United States. Well, that's proper. And so now, right, I, Abraham Lincoln, President of the United States, again, not President of the United States of America, right? So Constitution that's with the military. It's going to suspend habeas corpus throughout the United States in the several cases before mentioned. But he's not doing it for everybody. So if you were to say to a judge, well, it's already habeas corpus suspended right now, they could say no. It's not. Because it's not suspended for everybody. It's only suspended for the people that were called out in this proclamation. And who did that include? Throughout the United States, in cases where, by the authority of the President of the United States, military, naval, civil officers of the United States, and any of them hold persons under their command or their custody, either as prisoners of war, spies, aiders, or abettors of an enemy, officers, soldiers, seamen, enrolled or drafted, mustered, enlisted, belonging to the land force of the United States, or as deserters thereof, or otherwise amendable to military law or the rules, articles of war, or the rules or regulations prescribed by military and naval services by the authority of the President of the United States, not the United States of America, the President of the United States, or for resisting a draft or other offense against the military or naval service. This is all military. Right? This is martial law stuff. So again, this is how the United States ended up under martial law. And as he's doing this, he says that I do hereby require all magistrates, attorneys, other civil officers within the United States, and all officers and others in the military and naval service of the United States to take distinct notice of this suspension to give it full effect. and all citizens of the United States that conduct and govern themselves accordingly in conformity with the Constitution of the United States, laws, Congress, in such case made and provided. Right? And how long is it going to go on for? It's suspended throughout the United States in the several cases before mentioned, and this suspension will continue throughout the duration of the said rebellion, so until the Civil War ends, or until a proclamation shall, by subsequent one, be issued by a President of the United States, be modified or revoked. Okay, well, those things didn't happen. Whatever Johnson did in 1866 didn't do this. It didn't modify or revoke this proclamation, and the rebellion is still ongoing. There's three ways that the rebellion could have ended. There could have been a special proclamation from the president, there could have been an order from the commander-in-chief, or there could be a peace treaty by Congress, and none of those ever happened. Didn't happen in World War I either. I don't believe it ever happened any war as far as that goes. So, we're in the middle of a war, both domestically and foreign right now. But as it said, right, well, what did Congress do? Well, what Congress had done, in fact, he mentioned at the beginning, this is why he was doing it, was that on March 3rd, 1863, they passed an act relating to habeas corpus and regulating judicial proceedings in certain cases, talking about giving the president the power to do it, and then what's supposed to happen is either the Secretary of State or the Secretary of War is supposed to send a list of people that are, under some sort of detainment because of this to the different districts. But after the grand jury for that district meets, if they don't issue an indictment, then you're supposed to be able to be released. Right? Shall be the duty of said judge, of said court, for who would make an order that any such prisoner designed a discharge from said imprisonment be brought before him to be discharged. Right? So I'm telling you, if you're going to court right now for any reason, you need to say, Judge, I want to be discharged in accordance with the act relating to habeas corpus and regulating judicial proceedings in certain cases. March 3rd, 1863. All right, if you Google this, you'll find it. An act relating to habeas corpus and regulating judicial proceedings in certain cases. I bet you don't even need to take the whole thing in, and Google will have some idea what it is you're looking for. Right? Take that in, give it to the judge, say, I want to be discharged by this judge. As far as I know, there's no grand jury who's ever had an indictment against me, so I want to be discharged. And the reason that you would be discharged is because the Civil War's never ended. There's not been a proclamation, an order by the commander-in-chief, or a peace treaty. And Proclamation 104 of President Lincoln has never been satisfied. Right? Say it with a straight face and see what the judge says. Well, that's kind of what I'm doing. Right? I don't have a court case that I was going to where I'm in court, but I did have a court case going, as it turned out, that I had kind of forgot about. So now we need to talk about that for a little bit. Let's go look at that again. And actually, this is how I found out that I had that court case, that I had started over a year ago, but forgot all about. Is I wrote to the Chief Judge of the United States District Court, Western District of Michigan, and asked her about this Proclamation 104. Right, Chief Judge, by Proclamation 104, Abraham Lincoln, President of the United States, proclaimed and made known to all whom it may concern that privileges writ of habeas corpus is suspended throughout the United States, and required all magistrates, attorneys, and other civil officers within the United States and all officers and others in the military and naval service of the United States to take distinct notice of this suspension and to give it full effect. And this suspension will continue throughout the duration of the said rebellion until the proclamation shall, by subsequent one, be issued by the President of the United States, be modified or revoked. So I am one of those whom concern, who understands the rebellion of Abraham Lincoln, President of the United States, reference is still ongoing, and I am unable to find evidence of subsequent proclamation from a President of the United States modifying or revoking Proclamation 104. So in the presence of the Lord God Almighty, can you please confirm who I need to contact to be discharged in accordance with an act relating to habeas corpus, da da da. Well, that ended up getting me this letter, right, which was subsequently put into this court case that was existing that I had forgotten about. Right, the United States District Court, Western District of Michigan, on February 8th. Don't call me Mr., please, but they did. No time to argue about it now. In the British system, a Mr. is like a stable hand, where the Esquire was the shield bearer of the knight, who is the nobility. So the knight's the nobility. Esquire is not nobility. They're just a hired agent, right? They're the shield bearer. And then the Mr. was the guy that cleaned the stables. Well, the Mr. doesn't have any rights. So you don't want to be a Mr. in this British system that they have. But anyways, there was this court case going on, which is in the Western District of Michigan. Sure enough, you can look it up. Find it right now, 1222 CV 00379. And so, hey, thank you for your letter, postmarked February 3rd. The Code of Conduct of the United States Judges prohibits the Honorable whomever from engaging in ex parte communications with litigants and their attorneys or others acting on their behalf. For that reason, your letter has been referred to me for a response. I will direct the clerk of the court to file this exchange of correspondence on the docket so there will be a complete record of communications. However, if you wish to ask the court for any relief, you need to file and serve a motion or other appropriate document. Right? For some things, you may even need to file a new case. The court cannot act on an informal letter. So they never said in this letter that habeas corpus was no longer suspended. Right? It didn't go on. So if you want relief, you got to follow these, their frickin' rules and do whatever they say. But they didn't tell me about the relief, or about the act. So, one of the things I did then is, I'm going to write her back. I'm going to take the Lord's advice, and it's in Luke chapter 18, verse 3, where he's talking about the widow who wanted justice, so she kept going to the chief judge. And he said in 18:3, avenge me of my adversary. So, Judge, avenge me of my adversary. Chief Judge Yarbu, is the privilege of writ of habeas corpus still suspended throughout the United States in the various cases identified in President Lincoln's Proclamation 104, suspending the writ of habeas corpus throughout the United States? Do not grieve the Holy Ghost. The gold fringe flag, your oaths of office, and Proclamation 104 make it your temporal duty to know if the suspension is ongoing. And Catholicism, because she is a Catholic, makes it your spiritual duty to undo or to do unto others as you would have done to you, and provide me a good faith answer. I have included a copy of President Lincoln's Proclamation 104 for your review. So she's not a Roman Catholic. She's out of Iraq. Can't remember what they call them, but there's like 24 different Catholic churches. There is no one holy Catholic and Apostolic church, which is my bitch, right? Even the Greek Orthodox, the proper name of the Greek Orthodox is the Greek Orthodox Catholic Church. They just choose not to use it. So you got Roman Catholic Church, a Greek Orthodox Church. God knows there's a bunch of Eastern Catholic churches and so forth and so on. They're just never ending. Right? So the problem with Christianity is there is no one holy Catholic and Apostolic Church. There's a bunch of fractured churches. That'd have to be for a different day. Today we're just dealing with the law. All right, but you want to claim to be a Catholic, ma'am, then it's your spiritual duty to do unto me as you would have done unto you, and provide me a good faith answer. And I want to know, is the writ of habeas corpus suspended throughout the United States in accordance with Proclamation 104? Because they're the ones that are supposed to bring it into effect. Okay, well, on the same day I got the letter, I also got this, which is, filing into this court case we're talking about. This is filing number 15, which is report and recommendation. And I showed in the last video, I'm not going to go find it again, but if you looked at all the docket entries to this court case, there hadn't been anything put in this court case or anything done since May of last year, 2022. And this all started because I tried to open a small claims case. Right, I was trying to open a small claims case in the small claims court here in Grand Rapids. First, I tried it to my small claims court, which would be the 63rd District Court, and they wrote me back and said I needed to do it where the defendant was. So, well, where's the seat of government for the defendant in Michigan? Well, or where I'm at, they're in the county, right? So so I was able to find, like where the court buildings and so forth are, and find out what small claims court, because there's like 8 or 9 of them for Kent County, that they were in, right? And that's the one that this is, the 61st District Court, where I said that I am an individual union member and that the defendant is a union, right? And blah, 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 blah. Well, they took this and then they wanted to move it, which is what happened. So now, people pretending to be the union's counsel said, well, we're going to move this because federal law says we can, move it to the district court, and that's what we're going to do. And, I didn't want that done at the time. I wanted it settled here, and they weren't going to do it. So, I just kind of let it sit. You can see, I said, who's the defendant? I said United States. I did not say United States of America. Well, when they moved this thing to the other court, to the federal court, and as it stands now, right, they've changed who I was going against, the United States of America. Right? That isn't who my court case. This is the whole bitch of my court case. I'm not suing the United States of America. I'm suing the United States Union. But it didn't seem to matter to them. They're going to go ahead and do their shit anyways, right? So, but nothing had happened, and all of a sudden, out of the blue, this report and recommendation comes up. And of course, it's not out of the blue. This is all tied together because I had written the judge, the chief judge. The chief judge got a hold of this guy. So I'm going to be putting this letter into the record. You guys need to, file something. And so this is the recommendation, right? So basically, it was saying that Ratluski filed this action against the defendant, United States, as a small claims affidavit of claim in the 61st District Court. All that's true. True, true, true. Perfectly true. I did it first time. I had to do an amendment. The United States removed the small claims case to federal court. Right? The United States. Didn't say United States of America. United States. This matter is now in the court on the United States motion to dismiss pursuant to something in the Rule 12, and this motion is unopposed. So the amended complaint. Now, I got to give Kent credit because he, basically he just put in here what I had said. Right, that I was seeks $200 because a foreign invader is governing the country by Jewish fable known as the Noahide laws. Right, MCL 600 2019 damages for forcible entry and detainer. I have been ejected from Constitution United States protections, full legal name identification, because they always want to use your middle name or middle initial instead of your legal name is your first name and your last name, and your first name, if you have more than one part, is whatever those are. So mine's Robert Allen. That's my given name. I don't have a middle name. And if you don't have a middle name, then there's no middle initial to be given. Right? So, because in the Real ID Act, it says your full legal name is your first names, middle names, last names, no initials, no nicknames. But if you go to Social Security, they'll say that your legal name is your first name and your last name, but they don't include the middle name. So they put Allen in the middle name box, and all of a sudden Allen drops out of the record, and it no longer matches the other records. It says that Robert Allen is the first name of of me. It's that's just wordplay. That's all they do. Anyways, I was bitching about all these things that, I don't have an electoral franchise. I can't properly register. I don't have a civil status. My Armed Forces of the United States, veterans' pay and privileges, and the enjoyment of one share of the public trust, just to name a few of my tenements, right? Because a tenement, if we looked at this law, it said lands or tenements, right? But a tenement is property of any kind. Could be incorporeal tenements. Could be fictional things like rights, titles, and interest. Right? They're damaged by the United States' failure to provide, by the United States as being a union, failure to provide a Republican form of government it guaranteed to Michigan and the other states under the 4th Article of the Constitution of the United States, thus facilitating the forced entry of a foreign invader, the United States of America, and posing as an unconstitutional democracy on the people of the United States and several states, run by the children of the devil, impersonated as senators, representatives, members of several state legislatures, executive and judicial officers of the United States, and of the several states who falsely claim this nation is governed by a Jewish fable known as the Noahide Laws, and not by the Constitution of the United States. And this is evidenced by 105 Stat 44. Just Google 105 Stat 44 and read what it says. Public Law 102.14. Right, the defendant, now, this is the magistrate judge talking. The defendant, United States, although when we looked at what it said the defendant was, it said United States of America. So this guy believes the United States is the United States of America, not the Union. Defendant, United States of America, seeks to dismiss this amended complaint for lack of subject matter jurisdiction pursuant to something or other in federal courts or courts of limited jurisdiction which possess only power authorized by the Constitution and statute. The basic statutory grants of federal subject matter jurisdiction are contained in, you got federal question and diversity of citizenship. It's to be presumed that a cause lies outside the limited jurisdiction and burden of establishing the contrary rests on the parties asserting the jurisdiction. The United States of America seeks dismissal on the basis of sovereign immunity, which is jurisdictional in nature. It's axiomatic that the United States, we don't know who this is, who this guy was talking about. You're talking about United States Union, United States of America, may not be sued without his consent, and that the existence of consent is prerequisite to jurisdiction. A waiver of sovereign immunity must be strictly construed, unequivocally expressed, and cannot be implied. In support of his claim, Michigan cites the statute which awards damages to persons ejected out of lands. Well, actually, it says any person who's ejected or put out of lands or tenements. It didn't say just ejected, put out, thrown out, in a forcible and unlawful manner, or being out is afterwards held and kept out by force, is entitled to recover 3 times the amount of his or her actual damages, or $200, whichever is greater, in addition to recovering possession, which is obviously what I wanted. I wasn't so concerned about the $200, but because it was $200, you could take it to small claims court. Just take the damages and get the recovered possession. That was the whole idea. Well, he goes on to say this statute does not waive federal sovereign immunity. Only Congress can waive several immunity. Rutluski also cites, now he's not calling me Mr. I had to give him credit for that because I bitched at him before for calling me Mr. I'm not a fucking Mr. Rutluski also cites a congressional joint resolution that designates March 6, 1991 as Education Day USA. As the United States points out, this resolution, however, does not provide a waiver for United States sovereign immunity to allow any type of claim against it, United States brief. Right? So now you're talking about the United States brief. This would be item 12 or docket entry 12 in this case. Well, anything in this case is not the United States. It's the United States of America, impersonated as the United States. Rutluski failed to present any federal statute in which Congress waived United States sovereign immunity to be sued based on this claim of ejectment. Now he says I'm having a claim of ejectment. Now, ejectment is a tort. But I'm not claiming a tort, I'm claiming a crime. which was whatever they called this up here. Right, damages for forcible entry and detainer, which this said, in a forcible and unlawful manner. So it's a violation of a state law. It's not a violation of my rights. It's a violation of the state. Defendant seeks, defendant, United States of America, also seeks to dismiss the amended complaint pursuant to for failure to state a claim. And all sorts of reasons that he wanted to do what he's going to do. Okay, so he put it in, and any objections to this report must be served and filed with the clerk. Served and filed. So it's like you got to serve this on the clerk and filed with the clerk of the court within 14 days after service of report. All objections, responses to the objections are governed by Western District, Michigan local court rule. Failure to serve and file written objections within specified time waives the right to appeal. All right, so I had to do something, which is I did, and I'm going to do a video on it. And I'm going to go away for a week or so. When I come back, we'll see if they had anything to say about it. So let's take a look at what I had to say. Alrighty, so I decided, well, I had better object. If I'm going to object, I'm going to go ahead and apply for some writs based on, right, 28 U.S.C. 1651, the All Writs Act, which is another thing I've covered in a recent video, right, and for other reasons. So what did I have to say? I said Ray Kent. We're just going to call him Kent from now on. Report and recommendation, number 15, is objected to. Appendix 1, a Manual for Court Martials, United States, 2019 edition, the MCM, is the Constitution of the United States, 1787. I've shown it to you. We're going to call that Constitution, proper case. The same being the Constitution, all persons subject to the Uniform Code of Military Justice, veterans, people in the military, a whole bunch of people, have a duty to support and defend, whose preamble declares, we, the people of the United States, ordain and establish this Constitution of the United States of America. Not for the United States of America, of the United States of America. This first sentence, the first sentence in its Article 2, established that the executive power shall be vested in a President of the United States. Showed you that. That's what's in the Manual for Court Martials. On the other hand, the Office of Law Revision Council of the United States House of Representatives, which prepares and publishes the United States Code and makes it available from its website, right, uscode.house.gov, a downloadable copy of the Constitution of the United States of America, 1887, with the superscript 1. We're going to call that the uppercase Constitution. Relied on by esquires and congressional member-elect impostors, whose preamble declares, we, the people of the United States, do ordain and establish the Constitution for the United States of America. Its Article 2 states, the executive power shall be vested in a President of the United States of America. These constitutions are not for the same nation. Plaintiff is a voluntary enlistee of the Armed Forces of the United States bound by oath, by the following oath of enlistment. I, Robert Allen Bretluski, do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic. I will bear true faith and allegiance to the same, and I will obey the orders of the President of the United States and the orders of the officers appointed over me, according to regulation, Uniform Code of Justice, so help me God. Right, so we can see here, it said Constitution of the United States and the President of the United States. Well, plaintiff and all other members of the Armed Forces of the United States, allegiance is to the Constitution of the United States and the MCN. Any other style document claiming to be a constitution governing members of the Armed Forces of the United States is a counterfeit, used in a scheme to defraud the United States. There is only one Constitution of the United States, and it is not the Constitution of the United States of America, 1787, superscript 1. Yet, according to the February 7th, 2023 edition of the Congressional Record, House, pages H715 to H720, a reading of the Constitution was part of the day's official business. the uppercase Constitution that was read corresponds to the Constitution of the United States of America, 1787, and its foreign President of the United States of America. This document read into the congressional record is not the Constitution the President or anyone else subject to the UCMJ has a duty to support and defend. The Constitution for the United States of America is foreign to all parties named in the plaintiff's suit. Plaintiff opened a suit against the United States, the Union, established by the Constitution of the United States. The plaintiff did not enjoin the foreigner United States of America to this suit, yet this third-party interloper's agents, esquires, claimed authority to move plaintiff's properly filed state small claim case against the United States Union into a foreign jurisdiction court that recognized the United States of America as the United States instead of the Union as the United States. Now these same esquires want to claim Kent's foreign United States of America court has the authority to dismiss plaintiff's claim because Kent's court does not have jurisdiction in the Union. And apparently Kent is willing to aid foreigners' war against the Union and Constitution of the United States. According to offices of United States Attorney's Introduction to Federal Court System, which you can find at justice.gov/USAO/justice-101/federal-courts. Right? It says cases that are entirely based on state law may be brought in federal court under the court's diversity jurisdiction. Duh. Okay, it was a state law case. It can be brought under the diversity jurisdiction. Diversity jurisdiction allows a plaintiff of one state to file a lawsuit in federal court when the defendant is located in a different state. The defendant can also seek to remove the state court for the same reason. But forever, whatever, it says it was the esquires, right? It was the esquires who were impersonated as the counsel for the Union, not the plaintiff that moved plaintiff's state law case to a federal court. Right? These foreign agents claim to be learned in the law, and if the esquires move the plaintiff's state law claim to a court lacking jurisdiction, then they are in criminal contempt of court. Kent, who is subject to the UCMJ, would then end up a defendant in a trial by court-martial for aiding the esquires' scheme. Take notice, this scheme by esquires has resulted in the Union defaulting in this matter for failing to make an appearance, right? Because the Union's never appeared. And the plaintiff is owed a default judgment in the plaintiff's favor, returning possession and tenants to the plaintiff. So says I. In the discussion portion of Kent's report and recommendation, Kent makes reference to the United States, such as the United States points out, or does not provide a waiver of the United States sovereign immunity, or defending the United States also seeks to dismiss. Kent's United States is not the Union United States. Plaintiff filed an affidavit and claim against in a state small claims court. Esquires of the United States of America cannot represent or rule the United States Union. Kent also insinuates that plaintiffs filed a private tort ejectment claim. This is a false statement. Forcible entry and detainer under MCL 629:18 is a crime, right? It said it was unlawful against the state that victimized the plaintiff. It is not a private tort. Kent also insinuates the plaintiff is pro se, when in fact the plaintiff is relator for the people of the state of Michigan, prosecuted a crime by conspirators impersonating as officers of the United States Union who terrorize citizens of the United States Union and commit forcible entry and detainer on their tenements. Plaintiff's status as a military member of the Armed Forces of the United States is established by enlistment, re-enlistment document, Armed Forces of the United States, or commonly known as a DD Form 4. You Google DD Form 4, you'll see what I'm talking about. Plaintiff's personal DD Form 4 proves plaintiff is a soldier for life, entitled to military due process, trial by court-martial, and a court of inquiry to determine who unjustly withholds plaintiff's tenements, such as pay, allowances, military identification, etc. Army Regulation 840-10, that'd be Section 3, Chapter 2, only allows the indoor display of a gold-fringed nation's flag in military courtrooms and military offices. As a result, civilians working under this flag in the United States District Court, Western District of Michigan, are subject to military justice under the UCMJ, and it will be aiding enemies of the United States if they allow the United States of America to impersonate as the United States Union in plaintiff's union matter. As 28 U.S.C. 1651, writs allows justice or judge of a court claiming jurisdiction to issue alternative writ, or any court established by an act of Congress to issue all writs necessary to provide relief. Plaintiff applies to this court to issue writs for the Secretary of the Army to convene a court of inquiry under UCMJ Article 135, excuse me. Let me read that again. Plaintiff applies for this court to issue writs for the Secretary of the Army to convene a court of inquiry under UCMJ Article 135, Courts of Inquiry, which is also 10 U.S.C. 935, so it's in the U.S. Code. Either way, they're covered. To investigate forcible entry and detainer of plaintiff's tenements as a larceny or other putative article. So if you went to the UCMJ, you don't have time to do it now, you'd find Article 135. It talks about courts of inquiry. It talks about who can convene them, and one of the people is the Secretary. Right? The Secretary of the branch. So I want the Secretary of the Army to do it. And, let's just call it a larceny. That's one of the, there's a section in the UCMJ of putative damages, putative articles, right? Things that are, crimes basically, and one of them is larceny. Okay, so that's one writ. Well, how about a writ for the Secretary of the Army to provide, under the Secretary's signature, the certificate of service described in 50 U.S.C. 4012, certificates of service, persons reporting missing, which, when you go look at 50 U.S.C. 4012, it says that that certificate is prima facie evidence of service. So everything else is just fucking talk. Right? It doesn't matter what it is. If it's not the certificate under the signature of the Secretary of your branch, then it's not the certificate of service that evidences your service. And I say if we had this right now, it would just show that we're all still in the service. We're missing an action or some other thing has been done to us. Right? And this is, the thing that's keeping us a defect in our civil status and causes the, between that and the writ of habeas corpus being suspended and Lincoln declaring under Proclamation 104 that for these groups of people it was suspended until the rebellion ended, which it has not, or the Proclamation 104 was suspended or modified, which it was not, right? They were still here. We're still under that same frickin' thing. Okay, and then a writ to discharge plaintiff in accordance with an act regulating habeas corpus and regulating judicial proceedings on March 3rd, 1863. Of March 3rd, 1863. Or some similar remedy that allows the district judge to maintain clean hands, support the Constitution of the United States, relieve plaintiff of detainment of tenements, and investigate why congressional members-elect failed to comply with an act to regulate the time and manner of administering certain oaths, that'd be your 1 Stat 23, and avoided executing its oath to support the Constitution of the United States, and then substituted the Constitution of the United States of America, 1787, superscript 1, for the Constitution of the United States, 1787, in the United States Code, and now impersonate as qualified incumbents of offices identified by the 6th Article of the Constitution of the United States. Their act of bad faith, avoiding their duty to execute the oath of 1 Stat 23, is a conspiracy against the United States and war crime. I declare the penalty of perjury the foregoing is true and correct. Executed on February 3rd, 2023. So here's 1 Stat 23. Right, this is the first law passed, signed into law, or first act signed into law after the ratification of the Constitution. An act to regulate time and manner of administering certain oaths. That the oath or affirmation required by the 6th Article of the Constitution of the United States, not Constitution of the United States of America, Constitution of the United States, shall be administered in the form following, to wit, I state your name, do solemnly swear or affirm, I will support the Constitution of the United States. Period. And nothing else. If you have to take another oath, it would be another oath. But this is an oath, just like this. No, nothing else added to it. That's the oath that satisfies the sixth article of the Constitution. And in the sixth article of the Constitution, that covers the senators, the representatives, the state legislatures, and the executive and judicial officers of both the United States and the several states. Now, it doesn't include military, because military isn't an executive officer. They're a military officer. Up until, just after World War II, right? And when they created the DOD is when military officers quit being executive officers and became military officers. Prior to that, I guess they were members of the executive. They were executive officers. So, where does that leave us after all this? It means I've filed this piece of paper. Where did I file? No, I filed an objection. And like I had said, I've been doing some other videos, obviously, and some of the things I talked about was the précipit, right? And it had said I had to serve and file my report and recommendation. So I did a précipit this time also and put it with my filing, right? That said that to the clerk of the said court, please find 4 copies of report and recommendation objection, application for writs to convene Article 135 Courts of Inquiry and other reasons enclosed. File 1 copy along with the only enclosed declaration of service into case, right, that we're talking about, 122 CB 379. Serve 1 copy on Beckerine, 1 on Kent, and 1 on Yarbo. Right, so précipit. Telling the clerk to do something instead of just sending this to the clerk's office. I seem to have just erased it somehow. Oh, well. Yeah, this is what Ken had said. Any objections to this report and recommendation must be served and filed with the clerk of the court. Well, serve it, soon sounds to me, you got to tell the clerk you're serving it and filing it. So you need to tell the clerk that's what you're doing. Not just mail it to them, which, I've done it many times as well. I just would put this in the mail and send it to them without anything on top of it and say, okay, well, here's what it said to do. But it's not telling the clerk what's going on. The clerk doesn't know what the judge said. They're just dealing with the docket. Well, now she does, right? Précipit to the clerk of the said court. Please find 4 copies of report recommendation. File 1 along with the only declaration of service into the case, and the other one into the other copies to these other judges. And I made up this thing I called a declaration of service. I had read this. I got to go find where I read it. The attorneys can certify, right? If you're an attorney, you can certify, do a certificate of service. But if you're not an attorney, you're supposed to do a verification of service. A declaration of service. So I, Robert Allen Berluschi, declare a person is required to be served a copy of report and recommendation, and other reasons have been served by mail or clerk of the court as indicated below. Right? The person served this was the United States Attorney, these judges, and the United States Attorney General, who is actually supposed to be served through the Solicitor General of the United States. That's right out of the Supreme Court rules. Supreme Court Rule 29. If the United States or any federal department or officer, agency, officer, or employee is a party to be served, service shall be made on the Solicitor General of the United States, room 5616, Department of Justice, 950 Pennsylvania Avenue, NW, Washington, D.C., 20530-0001. So I did, right? Now, before when I had done something like this, I would have just sent it to the Attorney General, and I had gone and looked down which is basically using the same address except this room number, and saying it's the Solicitor General. But when you go to the Department of Justice website, it says the mailing address, Department of Justice is Department of Justice, 950 Pennsylvania Avenue. Right? You didn't, miss the big part. It's supposed to go to the Solicitor General of the United States, room 5616. So I'm making sure this time they know that I've sent a copy to that office. Right, so I sent a declaration of service, and in my declaration of service, I served it on the attorney that's handling the case. And anytime you have a case against the United States, you're supposed to serve the United States Attorney General. So, did that. Care of the Solicitor General. Going to serve these judges. Make sure they all get a copy. Make sure the clerk gets a copy. Everybody's been served. And I sent that, and I sent the précipit telling the clerk what to do instead of just filing papers into the court. I'm going to say, well, I guess maybe, because there are précipits, and there is, federal précipit papers. You can go look up federal court précipit and find copies of them. And précipits are what you use to tell the clerk what to do. So if you don't tell the clerk to file it, maybe they don't file it. Maybe they just pretend to file it. And then, of course, the document itself. So now, where are we at today? So that was all up until now. And this is using Pacer, right? So now I'm on the Western District of Michigan side. I want to see if they had put it in yet. But I noticed this now. Notice will be unavailable Friday, February 17th, 5:30 until Sunday at 5 o'clock. So they're doing something to the system. I don't know if this was here yesterday when I went and looked, but it very well could have been. I'm not saying what I did has anything to do with that. I'm just saying, well, they're going to shut down the system here soon. And I want to go look at court information. And if you go here, you can look at the last 24 hours of entries. So let's see if they put mine in the court case yet. Mine on page. No, I should be able to start typing my name in. R-Y-T. No, I didn't make it yet. So, now they got this yesterday at about 11 o'clock. So I've had it 24 hours. So, be interesting to see if they put it in over the today or tomorrow before they shut down their system. But or are they going to send it back to me and say there's something wrong with it or whatever? I don't know. Other time I've sent something to the court, they ended up, getting into a docket. And if I were to, well, I look at real quick. We'll go under query. I got to go get the court case number though. Hang on a second. Okay, so I put the court case number in, find the case. It says that's how it is in the system. So run the query. That's Rutluski versus United States of America. Date of last filing. Now this says something was filed 12/15. That's interesting, although it doesn't show up. Let's take a look at it. Let's see what the last document was. Hang on here. Yeah, okay. Yeah, it said there's one was filed yesterday. So let's go under document report or docket report. Filed or entered. You could pick the days. I'll just do the whole thing. Let's just take a look at the whole. Let's run the report. Yes, I did. Outstanding. So yeah, here it is. Rutluski versus United States of America. Who's all involved? Right, letter from court, right? Objection. That's what I put in. Certificate of service, I put in. But I don't see where they said anything about the précipit. The 16, that's the letter that the judge put in. And my objections been put in, and let's see, certificate of service by plaintiff Robert A. Rutluski, objection report and recommendation 17. Okay. All righty, well, good. Hey, they did put them in. So now we'll see what they have to say. Right now they have to answer. They could say that I didn't do it right. You didn't follow procedure, so we're not going to give you the answer you want, which is always a possibility. That's why I did the video. You can see what I did and why I'm doing it. And, you know, I'm not going to allow somebody to say that the Constitution, that the people pretending to be Congress right into the frickin' congressional record, is the Constitution that I took an oath to support and defend. Neither is it the Constitution that anybody that is associated with the gold fringe flag took an oath to support and defend. Right? That is the United States as a union, not the United States of America as a entity of some kind. So people always say the United States is a corporation. Not everybody. Some people want to say the United States is a corporation. Well, you're talking about the United States of America, that thing of King George's. I'm not talking about that. I got nothing to fucking do with it. It's got nothing to do with me. And you're going to have to learn that. It has nothing to do with you, but you are under the Constitution of the United States. That's where your protection is. So you need to tell them they're wrong and they're using the wrong Constitution. Right? And somebody besides myself yell about it a little bit. Maybe something will happen. But hey, it's out there again. Thank you, Lord, for letting me do this. And I got it in, got it done. Go about my business and come back in a week and we'll see what happens. Until then, you'll have a good time and, you know, I'll talk to you when I get back. But don't send me any emails or don't make any phone calls. I'm not going to be able to respond. Okay. I guess I want to show one more thing. I was looking at just before I shut down. I was like, oh, I want to make sure I put this in the video. So you go to Pacer's website if you have an account, because you can have an account for free. You have to give them a credit card number, but if you don't do over a certain amount, then they don't charge you for looking at stuff. Right? So you got to be careful how much you look at, because they charge you 10 cents per page. But anyways, go down here and I put in Western District of Michigan. That's the court I want to go to, and hit submit. You end up at this page here, right? Welcome to the United States District Court for the Western District of Michigan. Well, then you go under court information. This is where I went before, right here. And here it says the court's name is Western District of Michigan. It doesn't say anything about being United States District Court. It just says it's the Western District of Michigan Court. Now, I've done this many times before, on many different cases. And if you put something in, and you go to this last 24-hour of entries, right, from the internet, and you were to put in like your name or something to do with the court case, you know, it would show. So like I put in 379, that's the last 3 digits of the court case. Well, there's nothing in here at all to do with 379. Today, and there wasn't yesterday, and I could try to put my name in. Nothing, right? Doesn't come up. However, I just showed you that if you go not this way, but if you went back here and went in here, do I need to do that? Yeah, because it's not there. You got to go here first, and then you hit query, and you put it in, and you run query. Right? It shows that there's a case, and it showed that there was something entered yesterday. And it says at the top of it, where's the one I just did? Right, which is this page. And what I didn't see before was it says up here, case referred. Right, so there's something different about the way this was put in here, because this docket looks the same as it normally would, just all the entries of what was put in and what they are. But these two here didn't show up when I tried it the other way, and any other time that stuff would have shown up without any problem. If you know, the day you put something in, you start checking for what's been put in the last 24 hours, it'll tell you if, you know, it had been entered or not. And it hadn't shown it been entered, but here it is. It's been entered. And the case has been referred. So I don't know what that means yet. I'm going to go look it up real quick and see if I can tell you. Hang on. All right, well, I'm not finding any really good reason. I mean, sending it to the magistrate judge is referring a case. So this could have always been there. I just never noticed this before up here in the corner. All I know, again, is the fact that, you know, it's showing that it's on the docket, but when you look to see what had been entered in the last 24 hours, and I've been looking since yesterday. It was never in there. All right, if we go all the way back here to wherever you are, right here, last 24-hour entries, it didn't show up. Now this says internet, so maybe because I mailed mine in, it didn't show up, and I'm making something about nothing. I really don't know. Just pointing out the facts. Okay. Y'all have a great day. See you now.